On May 5th, 2011, I filed what was known as a First Amended complaint.
Richard Fine is back, fighting to stop the rampant tide of judicial bribery. He names judges by name and exposes their sad, sordid tale of judicial corruption. Next on Full Disclosure.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this latest update on the crusade of Dr. Richard I. Fine in his campaign to restore integrity to the California justice system. Dr. Fine is fighting to restore his law license and win back his profession of more than 4 decades. In his complaint, he listed all of the major conspirators he alleges were ultimately responsible for destroying his career.
The State Bar of California, the Board of Governors of the State Bar of California, the Chief Trial Counsel of the State Bar of California, the State Bar Court judges individually of the State Bar of California, and the individual judges of the California Supreme Court.
We asked him to explain what was in his complaint.
This complaint had 4 causes of action in it. Cause of action number 1 was to declare the California's moral turpitude law unconstitutional.
California is the only state in the Union that has a moral turpitude law for civil action.
The second cause of action was to declare California's law of involuntary inactive enrollment unconstitutional. And that's California's law that says that the State Bar can declare you involuntarily inactive without giving you any notice that they're going to do that. That in and of itself is a violation of the United States Constitution.
He supported that declaration, citing a case, Henri Refalo, which states that you can't do anything to a person without notice.
The third cause of action is to declare Senate Bill SBX 211 that gives the judges and other government employees and officials retroactive immunity from criminal prosecution, civil liability, and disciplinary action for the illegal payments that the counties give to the judges.
That was the result of the case Sturgeon versus County of LA, although the Sturgeon 2 sent the issue back to the legislature and nothing has happened since that ruling. His fourth cause of action is the meat and potatoes of his complaint. It voids his disbarment.
To declare and to enjoin the State Bar and all of the defendants from taking any action against me with respect to their having disbarred me based upon the fact that the Supreme Court judges violated the law and engaged in corruption by having received illegal payments from counties.
Then he went on to name the names of those judges he alleges had violated the law. It's a who's who of the California judicial system.
Former Chief Justice George, Associate Justice Moreno, and Associate Justice Kennard all received illegal payments from Los Angeles County. Associate Justice Chin and Associate Justice Corrigan received illegal payments from Alameda County. And Chief Justice George and Associate Justice Baxter were on the Judicial Council, which wrote Senate Bill SBX 211 that gave all of the other justices and every other judge in California the unconstitutional retroactive immunity.
A federal judge quickly responded with the judge's usual tactic by trying to dismiss his complaint.
This particular magistrate judge has tried to stop me since 2008. She has now reached the end of her line.
Dr. Fine compared the current court corruption to the way government officials in Alabama tried to subvert the federal anti-segregation laws back in the 60s.
This situation where these judges and the state legislature of California has engaged in this type of criminal type of conduct by both violating the law and by passing legislation to get out from under the law is very analogous to what happened back in the days of segregation.
He explained how the Southern politicians and judges conspired against the new federal mandate that prohibited segregation.
After we had the decision of Brown versus the school board, which removed segregation, what the South did is the legislators in the South and the judges in the South passed laws and tried to enforce laws to reinstitute segregation on a statewide basis.
The Supreme Court stepped in, and the good old Southern boys were stopped in their tracks.
The Supreme Court said, wait a minute, we aren't going to let that happen. And in a case called the Cooper versus Aaron in 1958, the Supreme Court said that Article 6 of the Constitution makes the Constitution the supreme law of the land. And they went all the way back to 1803 in a famous case of Marbury versus Madison.
Dr. Fine quoted Justice Marshall, who wrote the unanimous opinion in Marbury versus Madison.
If the legislatures of the several states may at will annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery.
He related this legendary case to his current complaint.
That is exactly what the California legislature and what the judges have done by enacting SBX 211 to get out from under their obligations under California law and federal law. Because the federal Constitution says that they must obey the Constitution of the United States and the laws of the United States.
It seems that obeying the Constitution and the laws of the land are somewhat passé in our current climate of government. Is Dr. Fine being a little naive? We're going to take a quick break right now, and when we come back, Dr. Fine will explain precisely how the judges are breaking the law.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show, and if you can't watch us on your local cable station, streaming video of complete shows when you want them. Fulldisclosure.net, when you need to know the news behind the news.
Welcome back to Full Disclosure and our interview with Dr. Richard I. Fine. Dr. Fine was explaining how the California Superior Court judges were violating both the U.S. Constitution and their oath of office.
They are violating what is known as the intangible right to honest services, which says that you can't take a bribe. Under California law, these payments are considered to be a bribe. They're considered to be obstruction of justice. They are considered to be conspiracy to obstruct justice. And the judges are required to pay the money back.
That would be true if we still lived under the rule of law. Right now, the judges continue to enjoy their $50,000 annual bribe with impunity. Senate Bill SBX 211 was created by the judges, written specifically for the judges. Dr. Fine suggests that the law has no merit because it was written by crooks.
The state bar and the state court judges were operating at the behest of the California Supreme Court judges because they are an arm of the California Supreme Court. But these judges, the California Supreme Court judges, were operating outside of being judges. Because when you break the law, you're no longer operating as a judge. You're operating in a criminal capacity.
And in fact, it was these same people who endeavored to have him disbarred when he started pointing fingers at them for continuing to take the illegal payments from LA County. The state bar that took his license had a serious conflict of interest. Two of the successive presidents of the state bar during the proceedings to disbar Dr. Fine were lawyers with the firms representing clients in the cases against Dr. Fine.
One of them, Sheldon Sloan, was representing Marina Pacific Associates in a case where I was representing the Coalition to Save the Marina and others against the County of Los Angeles and Marina Pacific Associates and Bellport Corporation. Sheldon Sloan represented Marina Pacific Associates and Bellport Corporation. He had a personal interest in my being removed from the case so that he could win. He was both a member of the state bar, vice president of the state bar, and the president of the state bar during the state bar proceedings. If he had such a personal interest, the state bar, and he was overseeing what the state bar was doing. So there you had a bias on behalf of the state bar.
But when Mr. Sloan's term as president of the state bar ended, the conflict of interest continued with the next state bar president.
The second state bar president was Sheldon Sloan's successor, Jeffrey Bleich. Jeffrey Bleich was a partner in the firm of Munger, Tolles, and Olson. Munger, Tolles, and Olson represented the County of Los Angeles in drawing the lease with Delray Shores in the case of Marina Strand Colony 2 Homeowners Association versus the County of Los Angeles. So he had an interest, and his firm had an interest, in seeing to it that I was removed from that case so that the Delray Shores project could go forward.
As in any crime investigation, to find the real bad guy, you should always follow the money.
Well, both Delray Shores and Marina Pacific Associates have a common general partner and basic owner, and that was the Epstein Family Trust. And the trustees of the Epstein Family Trust were Jerry Epstein and his wife, Pat Epstein. Now, things get a little bit deeper, because when you look to see the contributions to the Board of Supervisors of LA County during the years in which the Delray Shores project was taking place, you find that Jerry Epstein and Pat Epstein and their associates, David O. Levine, who was, quote, Jerry Epstein's chief of staff, gave money to Michael Antonovich and Don Knabe, who were two supervisors of the LA Board of Supervisors.
What was the effect of giving thousands of dollars in political contributions?
The Board of Supervisors voted on May 15, 2007, to approve the Delray Shores project. There were 4 votes. Because these supervisors had each received greater than $500 in April 2007, which was less than 12 months before the vote, their votes were illegal under a case called City of Torrance versus Break Zone Billiards.
If votes by Supervisors Antonovich and Knabe were illegal, according to Dr. Fine, their votes shouldn't be counted in the total.
That meant there were only 2 votes in favor of the project. You needed a quorum of 3 votes in order to pass the project. So the vote for the project was illegal. That meant that in the Marina Strand Colony 2 homeowners case against the County of Los Angeles, you could never get the project through.
But the project went through because the lawyer hired by the citizens to stop the project had been ambushed by the state bar.
I'm now in this lawsuit against these people. During this period of time, the state bar declares me to be involuntarily inactive, removes me from this lawsuit, removes me from the other lawsuit where the Epsteins are involved.
The developers used their money and their legal influence to control all aspects of their project, trusting that the state bar and the county-paid judges will keep Dr. Fine from interfering with their investment.
Everything's going along very well for them because in addition to that, they have paid the judge, Judge Yaffe, who's involved in the Marina Strand Colony 2 lawsuit, approximately $680,000 of illegal monies. They've paid Judge Burley, who was involved in the Marina Pacific lawsuit, Marina Pacific Associates lawsuit, approximately $608,000. So now you have illegal contributions to the Board of Supervisors, bribes to the judges, and I'm kicked out of the case.
You may think that's enough. The developers, the county supervisors, the state bar, the judges. Dr. Fine alleges they are all involved in corruption. Could there be even any more to the story?
It gets worse. Because during the same period of time, I was retained by a group, by the Grassroots Coalition in a case called Atina versus the City of Los Angeles. And this had to do with the Playa Vista development right here in Los Angeles, which is one of the largest developments in the history of the United States. And they had suffered a writ of mandate requiring them to go back and redo their environmental impact report. They didn't want to do that. I was brought in to enforce that mandate.
The enforcer, Dr. Fine, found some interesting transactions had occurred between the developer and the LA City Council. Remember, follow the money.
In the process of enforcing that mandate, I discovered that Playa Vista or Playa Vista Capital Corporation had paid money to 11 of the 15 members of the City Council within 12 months of the time that they voted on Playa Vista projects. In addition to that, the city controller, Laura Chick, who had formerly been a council person, came out with a report, I believe it was on June 6th, 2007, or June 5th, 2007, at which time she said that everything regarding Playa Vista with respect to methane gas and other things was perfectly all right.
And so what was the result of her endorsement of the project? Guess what?
On June 6th, Playa Vista Corporation gave a $5,000 behest in her name to a charity, one day after the report came out. And while the report was still being considered, well, this is an illegal behest. Laura Chick gets appointed by Governor Schwarzenegger to the Board of Governors of the State Bar of California as a public member. Now, a public member is different from a lawyer who's elected amongst lawyers. Public member is especially entrusted to represent the interests of the public for integrity, for honesty. They're supposed to be super clean. And here we have good old Laura grabbing that behest. Laura Chick has an interest in getting rid of me on the Playa Vista case.
Going into the disbarment proceedings, the deck is obviously stacked against Dr. Fine.
So we now have 3 members of the Board of Governors who are overlooking what the state bar prosecutors are doing, interested personally interested and financially interested in getting rid of me from cases that I am on where I am basically prosecuting them or their clients, where underlying corruption is taking place. And that gives you the underlying interest. But wait, we're not over yet.
You mean there's still more collusion and more corruption? Yes, this sad tale still goes on and on. But we need a break right now to take a breath and rejuvenate our spirits. We'll be right back.
For the news behind the news, wherever and whenever you want it, go to fulldisclosure.net and get programs on topics affecting you, weekly updates and alerts on hot topics, video streaming of Full Disclosure episodes. It's award-winning, hard-hitting, corruption-fighting news coverage. And it's only available at fulldisclosure.net. Fulldisclosure.net, the news behind the news.
Welcome back to Full Disclosure and our update with Dr. Richard I. Fine. Dr. Fine was about to explain another example of the corruption he faced as he fought to prevent his disbarment.
During the course of the state bar proceeding, they had a state bar judge, and his name was Richard A. Hahn.
Richard A. Hahn is a contributing member to our society who was active in the community. At this time of the Fine disbarment proceedings, he was a member of the Board of Governors of the Southern California Special Olympics.
Sitting with him on the Board of Governors of the Special Olympics was a member, a representative of the County of Los Angeles. Sitting on the Board of Directors of the Southern California Special Olympics was someone from the firm of Latham and Watkins. Latham and Watkins was the group that gave the $5,000 behest in the name of Laura Chick. That may be bad, but it even gets worse. During the time that Richard Hahn is sitting and deciding my case, which involves illegal contribution, illegal payments from LA County to the judges, LA County gives $30,000 to the Southern California Special Olympics. There does not appear to be a record of any money given before, and there does not appear to be a record of any money given after. But in that period of time, they gave $30,000.
Just a coincidence? Yeah, right. Even if there was no effort on the part of the county to influence Judge Hahn in the proceedings against Richard Fine, Judge Hahn was obligated to disclose the donation by the county to his special cause.
Richard Hahn, a man of integrity, does not disclose this contribution. And when the contribution is disclosed, he refuses to disqualify himself. And his friends on the state bar judges also don't disqualify him. In addition to that, when his disqualification motion was brought forward, it was brought to another judge who was sitting on another board in San Francisco with a member of the law firm of Munger, Tolles & Olson with Jeffrey Blythe.
Just in case you're having difficulty keeping score, Jeffrey Blythe was serving as president of the state bar during the Fine proceedings.
Munger, Tolles & Olson, it turns out, gave money to the Board of Supervisors. So we have all of these circles of all of this corruption, of all of this money flowing. And who is the one person that is standing in the way of all of these people? Little old me. Who is the one person that they feel they have to get rid of? Little old me.
So how did they get rid of him? Judge Yaffe was apparently assigned to stop Dr. Fine and his clients from interfering with their plans.
Judge Yaffe, in the Marina Strand case, when I end up exposing all of this, throws me in jail. In the end, he ends up releasing me after I reported him to the Commission on Judicial Performance. And he became concerned, I'm sure, about not only losing his job, but being prosecuted for theft, for bribery. But he also resigned.
As a direct result of the ongoing pressure from Dr. Fine, other judges, he alleges, conspired against him are starting to fall.
At this point in time, Chief Justice George resigned precipitously. Associate Justice Moreno suddenly has announced his resignation, claiming family business. So we have 2 California Supreme Court justices that have resigned, Judge Yaffe that has resigned. We have, in the Marina Strand case, Judge Jones, who recused herself, and we have Judge Chalfant, who has recused himself. Sitting at the bottom of all this is the lowest person in the federal judicial system, Magistrate Judge Worley, who is thinking that she is going to stand up for all of these judges and try and twist the law to stop the latest complaint. That is not going to happen. She is not going to be able to wage war on the Constitution. It's as simple as that.
He summarized the conspiracy of corruption that plagues Los Angeles and may be endemic in every community.
In the end, we have a money trail that starts with the developers giving money to the supervisors, who then make illegal votes in favor of the developers. The supervisors give illegal payments to the judges, who then vote and decide cases in favor of the county and the developers.
We want to thank Dr. Fine for appearing on Full Disclosure once again. We want to know what you, the viewers, think. Do you see this same conspiracy of corruption in your community? Please call our Full Disclosure Town Hall number and tell us what you think at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news.
Look at it and said, wait a minute, we'd better get everything back, to impose our cover-up right now before the next thing hits. And the next thing is hitting right now.
What's hitting right now? Dr. Richard Fine is exposing a cover-up by the Federal Department of Housing and Urban Development, who he claims is working in collusion with a shady developer. Now the local corruption has gone federal. You'll see it next on Full Disclosure.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this alarming discovery of an apparent collusion and then an overt action by an agency of the federal government to cover up and suppress what appears to be a criminal act. Mathematics professor Daniel Gottlieb received an interesting document as a result of a Freedom of Information Act request. It was an application for a loan guarantee from HUD, the U.S. Department of Housing and Urban Development. The application was for a loan guarantee to construct a development in Marina del Rey that Dr. Gottlieb has been fighting for years. He thought the application contained revealing information that should be disseminated far and wide.
And I disseminated it to the press and sent it to many, the Times and fulldisclosure.net, and it got put on the website. And I referred to it in documents myself because I could point out where there were misconceptions, lies, and untruths.
Suddenly he was presented with a very menacing letter ordering him to cease and desist, making any and all disclosures, including dissemination or copying the information disclosed therein. He was ordered to destroy all copies and to report the names and addresses of any and all recipients of the documents. This urgent demand made him wary.
So I thought that if I had to pull it back, that they were frightened that they might be accused of fraud or something. And I thought that they were trying to intimidate me.
And being full disclosure, we sought out the best possible person to explain the sensitive nature of the HUD application. We asked Dr. Richard I. Fine, who was the former attorney representing homeowners who opposed the developer, who submitted the questionable application. We asked him to review the document and give us his take. He made it very clear why the U.S. Department of Housing and Urban Development was so intent about retrieving this revealing document.
The same people who were involved in the Marina Stand Colony 2 homeowners lawsuit have committed fraud on HUD, the Housing and Urban Development Department, in seeking and obtaining an insurance policy for $125 million to guarantee their loan to put up the New Shores project.
Jerry Epstein is the controversial developer whose company is attempting to redevelop the luxury apartment complex called Delray Shores.
In order to do that, they had to go through and do two things. Number one, they had to get their current lease extended in order to make this project work, because you can't build a new project and get it paid off in the short period of time that was left on their current lease. And second of all, they had to be able to go out and get the approvals to do the new project and then ultimately get the financing to do that.
Marina del Rey is county-owned land. It was originally destined to be a small boat recreational harbor for the citizens of Los Angeles County. To move his housing development forward, the Delray Shores project had to pass in review by the county.
Now, in order to have that happen, they had to have the Board of Supervisors renew their lease and also approve the project. In order to do that, they had to go through an environmental impact study, or commonly known as an EIR. To get the approval from the Board of Supervisors required a vote of 3 of the 5 supervisors.
A simple majority should have been no problem, but according to Dr. Fine, there were circumstances that compromised the vote.
Now, there's a law that says that you cannot, if you're a supervisor, you cannot vote on something if you've received a donation or a political contribution from someone within 12 months of the vote. What Epstein and his group did is they contributed to Supervisors Antonovich and Kanabi in April of 2007. In May of 2007, Supervisors Kanabi and Antonovich voted in favor of this particular project.
With two of the supervisors out of the picture, what was the problem, we ask him?
Now, there are only 4 people that voted. 2 of those votes, Kanabi and Antonovich's votes, were illegal. That meant that there were only 2 votes in favor of the project. Project didn't pass. What the county did is the county said, wait, project passed. Right then and there, you had an illegal vote approving the EIR for the project.
This became the grounds for the lawsuit he filed against the Delray Shores project.
You had step 1, the contributions from Epstein, Jerry Epstein, Pat Epstein, and David O. Levine, Epstein's chief of staff and manager to these particular people. You have the county going in and making a false approval, an illegal approval. We sue. I say we, Marina Strand Colony Homeowners Association number 2 sues. Judge Yaffe becomes a judge. The county had been paying Judge Yaffe from somewhere in the mid-'80s all the way up through this period of time, illegal payments, which in these illegal payments, according to the case law and the statutes, are bribes, approximately $860,000. Judge Yaffe ends up saying, well, project can go through. What you need to do is you just have to go through and get a reapproval with respect to some grading and things on this order.
The reapproval process gave Dr. Fine even more grounds for his lawsuit.
The next vote, they gave money to more supervisors. So by this time they had 3 out of the 4. In fact, they might even have had 4 out of 5. I don't remember the exact number, but once again an illegal vote. So the second approval was no good either.
So Dr. Fine began pressing to void the county's illegal series of approvals, but he also forged ahead in his campaign to bring light the illegal payments from the county to Judge Yaffe. It became a disaster for him. We'll hear about how the most powerful people in California's judiciary used their positions to stop Dr. Fine on behalf of the developer after this short break. We'll be right back.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show. And if you can't watch us on your local cable station, streaming video of complete shows when you want them. Fulldisclosure.net, when you need to know the news behind the news.
Welcome back to Full Disclosure and our expose of the apparent collusion between a local developer and a federal agency. Dr. Fine was explaining how the lawyers for the developer used their positions on the state bar to destroy their opponent on the Delray Shores project.
In this period of time, and this is when the state bar had first declared me to be involuntarily inactive and then went after me to disbar me, Sheldon Sloan, who was Epstein's lawyer in another case that I had against Epstein, and he was the president of the state bar, and Jeffrey Blythe, who represented the county in negotiating the new lease with Epstein, who was the president after Sheldon Sloan of the state bar. Both were on the board of governors of the state bar. And then, in addition to that, Laura Chick, the controller of the city of LA, who I nailed for taking an illegal behest in her name, all were up on the state bar board of governors. They went after, they had an interest in my being out as being a lawyer because naturally I was in lawsuits against them and they weren't going to be winning as long as I was there.
Even after he was removed from the case, the persecution continued. It was their purpose to utterly destroy Dr. Fine and make an example of him, to teach everyone else to fear the dire consequences if you accuse the developer, politician, judge triad of complicity and collusion.
We had this whole thing happening to get rid of me. So I'm off the case. But then Yaffe goes in to makes an illegal sanction against me. Or it wasn't really a sanction. He makes an order reinstating the Marina del Rey case because I had missed one day on a filing. He reinstated the case. He did not grant my order to get a judgment in our favor because the county was 60 days late. That he said, oh, no problem. These things were unconstitutional. And then he decided that he wanted me to pay attorney's fees of $47,000. And I said, Judge, you can't do that. You're on the take. You're getting a bribe. You can't do anything in this case. He said, so what?
Not only so what, but he also threw Dr. Fine in jail for more than a year. Meanwhile, the Delray Shores project was struggling to go forward.
What occurred during this period of time is that Epstein didn't have the money to go forward with the project. So he got a delay, another illegal vote from the county, to delay going forward with the project. In that delay, he ended up selling off half the project to an insurance company. They had to then go out and get a mortgage. So they went to a company called Red Mortgage Capital, LLC. And they obtained from Red Capital Mortgage, LLC, a mortgage for approximately $125 million. Now, Red Mortgage Capital, LLC, however, would only lend if they got insurance from HUD on the mortgage. So if the mortgage would default, they wanted to have the guarantee. And that's how HUD gets involved. The fraud that we are now dealing with is that we now have the HUD application. As part of that application, they have to fill out the form, which is going to talk about, is there any past and present litigation against any of these companies? And also, what are the financials of these companies?
He explained how the application was filled out with a purposeful intent to hide past and current litigation.
The mortgagor, which is now Shores LLC, well, that doesn't have any current or past legal actions against it because, as HUD says, this there are no records available because this is a new entity. Nothing's available against that. However, it turns out that Delray Shores LLC was the first company that we sued because that was the company that was operating Delray Shores, the buildings. So Delray Shores LLC should have really reported that they were initially sued.
But they didn't record that on the HUD application, which Dr. Fine claims as a violation of federal law.
There is nothing in here in the HUD reports that talks about the past and present litigation. But we know that the past and present litigation existed and is existing and is currently going on. So here we have the entire fraud by the Epsteins, the Douglases, and actually, because Guardian Life is now involved, by Guardian Life.
The next issue is the money invested. The insurance is to cover the loan. Who is investing in the Delray Shores project?
In all of this, they speak of their various investments and things, but there's nothing showing that these people are putting any money into the project. In Guardian Life, they have Guardian Shores LLC. That's the new 50% owner of the shores. And there they say it's a new entity that has not yet been funded by its parent, Guardian Life Insurance Company of America. And there's no question Guardian Life is a very, very big and substantial company. But there's nothing in here that says that Guardian Life is either going to fund the subsidiary, or second of all, Guardian Life is going to guarantee the subsidiary, or that Guardian Life is going to guarantee the project. So right now you have a skeleton bare bones project that is sitting here with nothing from anybody saying that this project is going to be going forward, and HUD's out there for $125 million on the mortgage insurance.
So what is the issue here, we ask him?
In summing it all up, what you have is you have the Epsteins, David O. Levine, their management person, the Douglases, and the insurance company, all not giving, quote, full disclosure or reporting what they're supposed to report to the government on the application for the insurance, which is a crime in and of itself. Then you have the HUD people not going through and doing the investigation of public records where they would have found all this information, and they would have found the fraud that was taking place on them. So they are actually part of this particular fraud.
We asked Dr. Gottlieb his reaction when he received the cease and desist letter. Did he feel the demand was appropriate?
No, I didn't feel it was appropriate. I didn't see how I could bring all that stuff back in. I thought it was a public document, and according to the original letter that came with the document, it said that there was no restriction on its confidentiality.
So initially there was no issue of confidentiality. We asked Dr. Fine if after viewing the application, if there was anything he thought should be kept as a government secret.
There's nothing legally secret about these documents. A HUD application is public. It's nothing secret. This is public business, and this is public money. And there's nothing secret about somebody applying for a $125 million mortgage guarantee.
So why was HUD so emphatic about getting the application and all the copies of the application out of circulation? Dr. Fine saw no justifiable reason at all.
You have a Freedom of Information request, which is lawful. You have the documents being provided pursuant to a Freedom of Information request, which is also lawful. And now you have somebody coming in and saying, give me the documents back, destroy all the information and everything else. But when you read the documents, you realize that this fraud has existed from beginning to end.
So what was the real purpose of the letter demanding destruction of all the copies of the application, we ask him?
I mean, it's a cover-up. There's absolutely no question about it. And what they are covering up is HUD's both not only incompetence, but its deliberate failure to go out and find the public documents. Or on the other hand, we can speculate that HUD found all these public documents and then hid them.
Was he suggesting that the government employees at HUD were working in collusion with the developer to get the loan guarantee approved? How much power does this developer really have? We're going to pursue this after this short break. We'll be right back.
For the news behind the news, wherever and whenever you want it, go to fulldisclosure.net and get programs on topics affecting you, weekly updates and alerts on hot topics, video streaming of Full Disclosure episodes. It's award-winning, hard-hitting, corruption-fighting news coverage. And it's only available at fulldisclosure.net. Fulldisclosure.net, the news behind the news.
Welcome back to Full Disclosure. We are exploring the apparent cover-up of an obviously faulty application to the Federal Housing and Urban Development Department. Dr. Fine summarized the corruption he has clearly established so far.
You're talking about a fraud that started as far back as 2007. Actually, it's 2006 to 2007, with the political contributions going to Antonovich and Kanabi running all the way through the present, and with illegal payments, bribes being paid to the judges going as far back as 1985. $350 million of bribes to the judges, political contributions continuously from 2006 from Epstein and his group into Antonovich, Kanabi, the others, Yaroslavsky, I know contributions went to him, and the other supervisors, illegal actions by the supervisors, illegal actions by the courts, lying to HUD on an application for a guarantee, which is also illegal, and HUD employees not doing the investigations and then going out and making the applications and putting deliberately false statements in their documents.
But were they deliberately false statements? Perhaps the people working on the HUD application merely overlooked some details. Perhaps as a typical government employees, they simply didn't do their job as carefully as they should.
This is so blatant that it isn't a question of somebody not doing their job. You've got to be the worst idiot in the world to not find public court records. And you have to be the worst idiot in the world if somebody says that there aren't any past or present court cases, and you're looking at the person that is involved in the court case to not look behind that particular statement. And they even say Jerry Epstein, trustee of the Epstein Family Trust, they say his HUD 92013 SUP also indicates no prior lawsuits or bankruptcies. And this is another interesting thing that we didn't discuss earlier. Jerry Epstein had a bankruptcy with respect to another condominium project. And that's public knowledge. So consequently, that didn't get reported. Wow. So you have two separate things in here that are not reported, that are easily checkable. You aren't talking about rocket science here. You aren't talking about genius. You're talking about somebody literally going in and checking out public documents. You're talking about a child going into the internet and plugging in Jerry Epstein in bankruptcy, or plugging in Jerry Epstein in lawsuits, and this stuff would come up in a second. So we aren't talking about negligence here. We're talking about somebody that deliberately is not doing it, or somebody that knows that the information is there and is writing a false and misleading report.
So we ask him to explain the demand letter from HUD that Professor Gottlieb received.
So the HUD letter that you have is HUD's attempt to cover up the crime and HUD's attempt to cover up HUD's failure to go out and investigate and to illegally go forward and give a mortgage guarantee or mortgage insurance based upon the crime.
So, does he really believe that HUD is complicit in a crime? Or is it merely government incompetence?
You have a government employee not doing his job, a government employee, and that may not get him indicted. But this letter does. This letter is now the cover-up. Destroy the documents. That's the cover-up. That is where HUD is taking the step too far. And this person who's an attorney advisor, he knows better.
And so, in his usual fearless style, he named the attorney.
The person that wrote the letter, and his name is Edward J. Campbell, attorney advisor, U.S. Department of Housing and Urban Development, Office of the General Counsel, 611 West 6th Street, 8th floor, Los Angeles, California, should be indicted. Because he is the one, he is the lowest person on the line of this particular cover-up. And every person that ordered him to write that letter and every person that is involved in the cover-up should also be indicted.
We ask him to suggest what should people do who have received the application and the demand letter. Should they comply with the demand letter?
Well, I'm not in a position to give people legal advice. My strategic advice to them would be that it looks to me like they've received an illegal letter from somebody that's doing a cover-up and committing a crime. And based upon that, I would take this letter to the U.S. Attorney immediately, and I would ask for the indictment of this particular person, and I would ask for an investigation of HUD immediately, within 24 hours. And I would also, since I understand that from the newspaper this morning, that there's evidently a HUD investigation, an investigation of HUD that's taking place by the FBI, you know, I would take the letter to the FBI and say, look, I'm being victimized, and be on record and ask that this person be investigated and that HUD be investigated, because it is clear to me that this is a cover-up and this is a violation of the law.
Naturally, we had to ask Professor Gottlieb what he plans to do. He seemed resolute and determined.
I'm going to write a letter to the U.S. attorney, or maybe the FBI. Well, I'll ask their opinion to see, do you think this is appropriate? Is it the beginning of a cover-up? This is an initial thing. They want me to suppress information, and I'm not sure that I want to do it, even if I have to go to jail.
Dr. Fine was equally determined.
This is our $125 million. There's absolutely no reason that that money should be out there based upon what's sitting in these particular documents. Absolutely none. It's no question that there's a fraud that's been committed, there's information that's been withheld. That in and of itself is a federal crime.
We want to know what you, the viewers, think. Do you believe that HUD is deliberately engaged in a cover-up to conceal their failure to investigate the Delray Shores application, and that HUD and the developer are acting in collusion? Please call our Full Disclosure Town Hall number and tell us what you think at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news.
Dr. Richard I. Fine, a former U.S. prosecutor, reacted to a letter written by an official from the U.S. Attorney's Office.
When this person says the United States Attorney's Office does not conduct investigations, he is bald out lying. In fact, I suspect if Attorney General Holder saw this letter, he'd be tearing out whatever hair he has left in his head, and he would probably fire this person immediately.
Is the U.S. Department of Justice involved in the scandalous HUD cover-up? A lot of evidence points in that direction. See the troubling facts right here, next on Full Disclosure.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this interview with Dr. Richard I. Fine. As a result of a Freedom of Information Act request, Dr. Daniel Gottlieb received some disconcerting documents from HUD, the U.S. Department of Housing and Urban Development.
And I disseminated it to the press and sent it to many, the Times and fulldisclosure.net, and it got put on the website.
It was a loan guarantee application to support the contested Delray Shores development in Marina Del Rey. The application showed several inconsistencies that some people consider fraudulent. Just a day later, Dr. Gottlieb learned of a letter demanding that he return the document and to destroy any copies and report the names and addresses of anyone who received copies.
So I thought that if I had to pull it back, that they were frightened that they might be accused of fraud or something. And I thought that they were trying to intimidate me.
But rather than submit, he went on the offensive.
Well, first I'm going to see if the person who wrote the letter actually broke the law. It seems to me like it's the beginning of a cover-up. So I'm going to write a letter to the U.S. attorney or maybe the FBI. Well, I'll ask their opinion to see, do you think this is appropriate? Is it the beginning of a cover-up? This is an initial thing. They want me to suppress information.
In response, Dr. Gottlieb received this letter. Dr. Fine quoted directly from it.
The United States Attorney's Office, and this is underlined in bold, does not conduct investigations, represent clients, answer legal questions, or give legal advice. Sincerely, and then it's the initials of somebody, Citizens Complaints Section.
As a former U.S. prosecutor, Dr. Fine identified the problem with the response Dan Gottlieb received from the U.S. Attorney's Office.
He reported a crime, and he asked them to investigate. So the response that he is getting from the United States Attorney, whose job it actually is to investigate and prosecute crimes, is totally wrong. First of all, the job of the Department of Justice is to investigate and prosecute crimes. That is the reason for them to exist. The United States Department of Justice impanels grand juries, conducts investigations, gets indictments, prosecutes people, and if they do their job correctly, convicts people.
Because of his proud history with the Department of Justice, he was saddened by their current and extraordinarily deficient response.
We had a different Department of Justice. I was in the Department of Justice from 1968 to 1972. It was a different era. It was an era where people went to the Department of Justice where we were bright-eyed and bushy-tailed, as we would say. We wanted to do the right thing. We had attorneys generals that wanted to do the right thing, and people had guts. It was as simple as that. You have to remember, when you look back on those days, those are the days when you had strong civil rights enforcement, when the antitrust department was looked upon as God's gift to business, because what happened in those days is that everyone that was involved in the antitrust world was a graduate of the antitrust division. Whether you were on the government side or whether you were on the defense side, everyone had literally gone through the antitrust division. So there was a tremendous respect for the antitrust laws. It was a different time. It was a time that we don't have today.
The U.S. Attorney's Office has refused to investigate the considerable evidence that there was an act of fraud committed on the loan documents in the U.S. Department of Housing and Urban Development. And they have also refused to look at the effort by HUD to cover up that evidence. This seems to implicate the U.S. Department of Justice. Are they involved in the cover-up as well?
This letter is showing, in fact, is indicating that the U.S. Attorney's Office is evidently trying to be part of the cover-up. I mean, we can actually go so far as to wonder what is happening in the U.S. Attorney's Office that they are refusing to even investigate this crime, to impanel the grand jury, to indict the people at HUD, and to prosecute them.
We asked Dr. Fine if perhaps the case is too difficult or convoluted for them to prosecute. He explained how the case is all laid out neatly in front of them.
Dan Gottlieb gave them enough credible evidence to start that investigation. He gave them enough credible evidence to go out and get a grand jury started. They can either do one of two things. They can either do a civil investigative demand, which is called a CID, or they can go criminally with a grand jury. Either one of those two avenues. Those are their main tools as to how they exist to prosecute crimes.
We're going to take a quick break right now, and when we come back, Dr. Fine will explain how simple the case would be for a federal prosecutor to get a conviction. And then he'll speculate on why they aren't following through. We'll be right back.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show. And if you can't watch us on your local cable station, streaming video of complete shows when you want them. Fulldisclosure.net, when you need to know the news behind the news.
Welcome back to Full Disclosure and our interview with former U.S. Prosecutor Dr. Richard I. Fine. The U.S. Attorney's Office has refused to follow up on a case involving the cover-up of a potential fraud within HUD, the Department of Housing and Urban Development. When we asked Dr. Fine if the case would be too difficult and expensive to prosecute, he demonstrated how easily it could be done, starting with the initial crime committed by the LA County Board of Supervisors.
I can take you through the evidence that would be presented to a grand jury to get you the indictment and probably the conviction of not only Mr. Campbell, who wrote the letter to destroy all the documents, but also the people at HUD. But in addition to that, Epstein, Jerry Epstein, Pat Epstein, David O. Levine, and the Epstein Family Trust, who made the political contributions to Kanabi, to Antonovich,
Supervisors.
the two supervisors, and later to Yaroslavsky and Molina, with the intent and the expectation, and we'll be able to show that without even questioning them, just from the circumstantial evidence, that these supervisors would vote in their favor for the projects within 6 months of having received these contributions. We would then be able to show that these votes took place.
These votes apparently were prohibited by law.
Well, if you give a contribution to someone with an expectation that they are going to do something for you, that's no longer a First Amendment political contribution. That's a bribe. So we can show that Jerry Epstein, Pat Epstein, the Epstein Family Trust, and David O. Levine gave these contributions to these supervisors, and we can show that the supervisors then voted for their projects within 6 months. That violates the public laws, the fair political practice laws. That gives you the circumstantial evidence to show that it was a bribe. The votes are illegal.
Dr. Fine explained how fraud has been perpetrated from the very beginning of the Delray Shores project. He made it clear that the ongoing corruption and systemic fraud has been demonstrated by the county officials time and time again.
We can show that because they did it not once, not twice, but 3 or 4 times. In fact, if we go over a course of a number of years, probably from the late 1990s all the way through the present, we can show a course of conduct by these individuals as well as the supervisors to get us into what we call a RICO violation.
Now, are you also referring to all 5 supervisors?
We're referring to basically almost all the supervisors that were in power during this time period, going all the way back to Burke, who, by the way, is now the head of the ethics sections for the United States Congress. Because when you look back, and I've looked back at the contributions, you will see contributions from the Epsteins and Levine going to Burke. And when you look back at the votes, you're going to see votes in their favor.
According to Dr. Fine, the LA Board of Supervisors has unashamedly done everything in their power to assure the continuing generous patronage given them by the developers.
Going back to the EIR, or the Environmental Impact Report, the Epsteins needed a positive vote by the supervisors on May 15th, 2007 on the EIR. At that point in time, 6 weeks before that vote, they gave money to Antonovich and Kanabe. 4 people voted in favor of that EIR. Not 5, but 4. 2 of those votes were Antonovich and Kanabe. Under the Fair Political Practices Act, those 2 votes were illegal because Antonovich and Kanabe received the money within a 6-month period of time. You now have an illegal vote. The vote's no good. The county covers it up. The next thing that happens is that we end up in the court case, the Marina Strand Colony 2 court case. The county has paid off the judge. They paid off Judge Yaffe. $860,000 have been paid illegally paid by LA County to Judge Yaffe. And we've traced it as far back from 1989 all the way up through about 2010 until he resigned. Those were illegal payments under the Sturgeon case. And basically, since those were payments from a party in front of Judge Yaffe to him, and under the Adams cases and so forth, those are bribes. Out and out bribes.
In flagrant violation of state law, the county money flowing to the judges has escalated to an astonishing amount.
The county has paid $350 million to literally every judge in the LA Superior Court from about 1985 through about 2010. They bought the entire court. So they bribed everyone. So when you take the payments to the supervisors doing the illegal votes more than once, but all the way through, the payments to the judges, you have a RICO violation. The Racketeer Influenced Corrupt Practices Act, RICO.
As Dr. Fine sees it, none of this is speculation or hearsay. Every charge is based on simple, documented fact.
Now you're putting this together with very, very straightforward evidence. We have the evidence of the contributions because we get that out of the public records of each and every contribution of Jerry Epstein, Pat Epstein, the Epstein Family Trust, and Epstein's Chief of Staff, David O. Levine. It's all public record. You can pull those in. We get the payments by the county to the judges from the county controller's office. Okay. And we just go in and we pull those payments. Public record. Tells you every judge how much they received, and they have records that they can produce within minutes from 1989 through the present, judge by judge. And they can go back into the 1985 period of time. It'll take them a little more time to do it. We pull in a member of the controller's office, put them on the stand. That's it. We will have all of those records. We show from the time of the payment to the votes of the supervisors what the supervisors voted on Epstein's projects during that period of time. So we have the linkage of the payment and the vote, which shows the violation of the Fair Political Practices Act, and it shows the bribe because it shows that the payment was given with the expectation that the supervisor would vote in favor of Epstein. The supervisor does vote in favor of Epstein, not just once, but time and time and time again, which shows you the pattern. We then take the money from the county being paid to the judges, and we show that the judges are ending up deciding in the county's and in Epstein's favor. And that's not only in the Marina Strand case, but in the Marina Pacific case also. So we have it all put together in a very nice package, which gives you the indictment. And as a former prosecutor, in my own mind, I think if I had to take that and put all of these things in front of a jury, we would get a conviction. Very simple.
Then why isn't the U.S. Attorney bringing this case forward? Richard Fine has some very troubling ideas why the Justice Department is sitting on their hands. We'll explain what he thinks is the reason when we get back from this short break. We'll be right back.
For the news behind the news, wherever and whenever you want it, go to fulldisclosure.net and get programs on topics affecting you. Weekly updates and alerts on hot topics, video streaming of Full Disclosure episodes. It's award-winning, hard-hitting, corruption-fighting news coverage. And it's only available at fulldisclosure.net. Fulldisclosure.net, the news behind the news.
Welcome back to Full Disclosure and our interview with Dr. Richard I. Fine. Dr. Fine explained how this situation has now become a federal crime.
So Epstein goes to HUD, and he says, HUD, 10% of my project is going to have low or moderate cost housing. I want you to go in and give me a guarantee for the whole project. And HUD, this group of highly intelligent individuals, and I say that with the greatest amount of sarcasm that I can muster, says that we're going to guarantee a $125 million loan on a 544-unit luxury apartment building where there's only going to be 54 units for low or moderate cost housing. No person in their right mind would even consider making a guarantee like that.
But even though the application was incomplete or completed with misleading statements, HUD approved the guarantee.
And I wonder if that is even within the HUD rules, and if it is within the HUD rules, what idiot drafted those rules that would allow a government agency using our tax money to go out and do something as criminal as this, when we have all these people who need loans to be able to stay in their houses.
Perhaps this one project wasn't big enough or expensive enough to warrant more attention from the Department of Housing and Urban Development. Aren't there bigger fish to fry in the U.S. Attorney's Office?
No, not in my mind. $125 million is a lot of money in anyone's book. And let's put this in perspective. It's a $125 million loan guarantee on a 554-unit apartment building, of which only 54 units are low or moderate cost housing. I want you to think about that for a second. That means that $125 million is being used to guarantee 54 units. That means that each low-cost unit is being guaranteed for approximately $2.5 million. That's a lot of money for an apartment. I mean, do you realize that you're taking and you're calling a low-cost housing apartment a $2.5 million apartment? I mean, that's a penthouse on the middle of the West Side. You're talking Beverly Hills, Malibu money here.
But it's almost standard operating procedure for the federal government to give away money by the billions of dollars every day. And this is merely a guarantee, not an actual expenditure. So perhaps this is really no big deal, we suggested to him.
HUD isn't that big that $125 million doesn't mean something to them. We're dealing in pure out-and-out fraud. Don't get starry-eyed over billions and trillions and all the rest of it. A dollar is still a dollar, and 125 million of them can probably cover Los Angeles County if we put all of them together, dollar next to dollar.
And this issue isn't merely the HUD loan guarantee. Dr. Fine pointed out how the county is also subsidizing the Delray Shores luxury development.
The County of Los Angeles gave Epstein in the lease an $11 million rent credit. In other words, he gets $11 million of credit for these 54 units. So he's getting paid double, because what happens is that the county is paying, we're paying for these units. We, the people, are actually paying for these low-cost units because he doesn't pay rent on the land for $11 million. So we, the people, are paying about $500,000 for each one of these apartments. We're building these apartments because that's our money. He owes us land rent money, which we are forgiving him.
And who is making this possible?
Our supervisors that got these contributions gave him a lease in our name which says you don't have to pay $11 million worth of rent. So who's really building these 54 units? We, the taxpayers, are building it.
Dr. Fine is adamant that nothing he is saying is speculation. With a minimum of looking, anyone could see all the facts plainly available, and all this evidence is available to convict all the parties involved if the U.S. Attorney would get off the dime and do his job.
Evidence is basically in public records, and you can get the evidence from the public records. You can put the custodians of records, as we call them, on the stands and get that evidence admitted. Let's face it, you are not, as far as Antonovich and Kanabi are concerned, they're defendants. They aren't going to be doing any testifying. Epstein is not going to be doing any testifying. David O. Levine is not going to be doing any testifying. Pat Epstein is not going to be doing any testifying. Representatives of the Epstein Family Trust aren't going to be doing any testifying. Kirk Douglas and his wife aren't going to be doing any testifying, and representatives of the insurance company aren't going to be doing any testifying because they're all defendants. This is pretty much a document case, and the jury can infer from the documents and from the patterns that occurred that the money was paid, the events occurred. It is not difficult for the jury to make the conclusion that the money went in, the supervisors voted, the illegality is shown by the law. With respect to Judge Yaffe, it's not hard to show he got the money. We even have his testimony in the Marina Strand trial that he admitted getting the money. There's no question as to what his decisions were. So this is a very, very easy case to put together.
We have the letter where the U.S. Attorney's Office is refusing to do their sworn duty as law enforcement officials. According to Dr. Fine, this letter undermines the credibility of the entire U.S. justice system.
I do not think that we could trust the local U.S. attorney at this point. I think it is doubtful that we can trust the U.S. attorney and the Department of Justice in Washington, because usually everything that a U.S. attorney does, he's the local representative of the U.S. attorney. Things like this would probably have been cleared by that person in Washington who oversees the local U.S. attorneys. So unless you have a rogue individual in here, which I doubt, having been with the Department of Justice, it's a very top-down organization, that I would venture to say that the entire U.S. Department of Justice is compromised based upon this type of a letter, and you're going to need a special prosecutor.
A special prosecutor? This story is getting bigger all the time. We want to know what you, the viewers, think. Do you think that the Department of Housing and Urban Development and the Department of Justice are in cahoots? Please call our Full Disclosure Town Hall number and tell us what you think at 1-800-867-7777. That's 1-800-867-7777. And if you leave your name and number, we'll get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. Please join us for part 2 of this interview, where Dr. Fine will explain how a special prosecutor will be necessary to stop the corruption that has now spread to the U.S. Attorney's Office. That's coming up next on Full Disclosure. I'm Leslie Dutton. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news. Full Disclosure's mission is to provide our viewers with the news behind the news. We recently received documents made available through a Freedom of Information Act request submitted to the Department of Housing and Urban Development for a $125 million loan guarantee on a luxury apartment complex in Marina del Rey known as The Shores. It appears that these documents did not disclose critically important information in the HUD application, and we have reason to believe that there may be other information missing from the documents we received. However, due to the compelling public interest in the Del Rey Shores project, Full Disclosure has asked legal expert on this subject, Dr. Richard I. Fine, to provide his comments on the information available thus far. Full Disclosure will provide updates on new information regarding this unprecedented project. Dr. Fine was the legal counsel to the homeowners opposing this massive Marina del Rey Shores development. In federal court documents, he points to the fact that lawyers for the Shores, developers, and LA County presided over a state bar proceeding against Dr. Fine at a time when he was the attorney leading the opposition against the project. Additionally, the lawyers for the developers continued to file documents urging the court to keep Dr. Fine in solitary coercive confinement, which lasted for 18 months without being charged or convicted of a crime, while they attempted to get their project and county lease approved along with the Coastal Commission. Although HUD has approved the $125 million loan guarantee, the Shores project and the actual approval of the project is still the subject of ongoing litigation in the state and federal courts.
No one would ever even think of writing a letter saying the department does not conduct investigations. We used to get calls from citizens or letters coming in, and they used to come across my desk. And we would investigate each and every one of them. It was unheard of that we would write a letter to someone like this. I mean, if any one of us did something like that, we would have been fired on the spot.
Why is Dr. Richard I. Fine, a former U.S. prosecutor, so disconcerted by a letter written by an official from the U.S. Attorney's Office? Is it because the malignant scandal that started with Los Angeles County has now metastasized into the federal government? Find out next on Full Disclosure.
Relentless, probing, fearless. This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the truth by revealing the news behind the news.
Hello, I'm Leslie Dutton. Today on Full Disclosure, we're bringing you the news behind the news in this part 2 of our interview with Dr. Richard I. Fine. As we discussed in part 1, there were several suspicious omissions on the HUD application for a loan guarantee, which Dr. Fine established as federal crimes. He also suggested that we, as taxpayers, were funding the Del Rey Shores Development Project in Marina del Rey. He questioned if HUD was providing the actual cash for the construction.
No, what it is that there's another company that is providing the mortgage money. However, what happens is that if this mortgage goes down, if Epstein doesn't pay the mortgage, the United States government, through HUD, will come in and pay the company that is supplying the mortgage money. So basically, the company that's supplying the mortgage money will lose nothing if Epstein defaults.
How likely is that? Before the home loan crisis, everyone thought real estate was one of the most assured investments. Is the Del Rey Shores development a risky venture, we ask him?
You have projections that people make as to what they think will happen in the marina's economy. This is not a low rent project. This is a high-end project. So consequently, the question is going to be, what is the high-end market going to be over the next 26 years or whatever, 40 years, whatever the term of this lease is going to be? And the question is going to be as to whether, in fact, they're going to be able to make their payments on the mortgage and keep the building up and everything else. That's a gamble. It's like any other gamble when one is doing a development. If you have a growing economy, and if you have enough people that can afford the rents, and the rents are high enough to cover your mortgage costs and your operating costs and your land lease costs to the county and everything else, the project will be successful. If your economy does not grow and is not continuing to expand, the project's going to go down.
In fact, during our investigation of Marina del Rey, we noticed large numbers of vacancies in the marina that were unprecedented. Perhaps high-end developments in and around the marina aren't as secure as they once were.
Reality is an entirely different story. It's a crystal ball. The only thing that's going to show who's right and who's wrong is going to be the test of time. And that's why the mortgage company said, look, we aren't lending you $125 million without a guarantee, because the mortgage company didn't necessarily believe that this project is sustainable to be able to pay back the mortgage. However, they said, if we get a guarantee from somebody, we'll lend you the money, because the mortgage company doesn't have anything to lose at that point.
We asked him to explain how someone would qualify for a loan guarantee.
If you go into a housing market, what happens is that if somebody has a good history of payment, basically puts in a decent down payment and had a good, shall we say, credit history, they would get a mortgage and the lender would not require any type of a guarantee. Now, on the other hand, if your credit wasn't that good, or if you might be young, or if your payment history wasn't that good, the mortgage company would require mortgage guarantee insurance. There's companies called MGIC, Mortgage Guarantee Insurance Corporation. And your lender would require you to buy a mortgage guarantee policy.
Was the problem the credit history of the Epsteins? Was that why the lender required a mortgage guarantee from them before they could have access to the cash?
I don't know what was in the lender's head, but I can tell from his actions, clearly the lender didn't think that the Epstein group had sufficient credibility to lend them $125 million based strictly on the security of the building. They wanted a guarantee, otherwise they wouldn't lend it. And there's a reason for that. And the reason for that is because the land underneath the building is owned by the county. And according to the county's lease, if Epstein defaults in any way on the lease, the county takes over the building.
So there were no tangible assets that could be used for collateral, like a normal home equity loan. The county owns the property, and the county wouldn't be held liable for any financial obligations by the lessee, Jerry Epstein.
So consequently, what would happen is you would have this building being owned by the county, or even at the end of the time of the lease, the building would come to the ownership of the county, and this mortgage company could be sitting out there with a problem.
The mortgage company still wanted a loan guarantee, and so the Epsteins declared a small percentage of their luxury apartments to be low-cost housing, so they could leverage a guarantee from HUD. And as Dr. Fine will explain when we come back, the money HUD is tying up in this guarantee could have been used to greater benefit than to facilitate lavish apartments in Los Angeles' biggest resort community. We're going to take a short break now, and we'll be right back.
In the government, there's a phrase used to restrict access to information. That phrase, need to know. At fulldisclosure.net, we want you to have all the information you need to be an informed citizen, unlimited access to all the information we've gathered on our TV show, and if you can't watch us on your local cable station, streaming video of complete shows when you want them. Fulldisclosure.net, when you need to know the news behind the news.
Welcome back to Full Disclosure and our interview with former U.S. Prosecutor Dr. Richard I. Fine. According to their website, HUD's mission is to create strong, sustainable, inclusive communities and quality, affordable homes for all. One of the most important goals of HUD is to meet the need for quality, affordable rental homes. Dr. Fine thought that using money that is supposed to help the poor with housing to build luxury apartments in Marina del Rey was a travesty.
On homes that are being foreclosed upon because the home is now worth 70% of what it's been worth before, the people have lost their equity in it, the home is worth less than what the mortgage is, the bank wants to foreclose on it and take the hit. Wouldn't it be a good idea if we came in as a government, we told the bank, you want to take the hit? Fine. We're going to buy the home for what it's worth right now. You bank, take the hit, and we're going to let these people, we're going to give them a new mortgage, let these people stay in that home at an ability that they can afford. Isn't that $125 million worth more being put there rather than being used at $2.5 million an apartment for a Jerry Epstein luxury development?
But the funds aren't actually being spent in this loan guarantee. They would only be used if the Epsteins default on their mortgage.
It's $125 million of our money that is going out the door. That money is committed, can't be used for anything else. And it's committed at $2.5 million per apartment.
$2.5 million? We asked him to explain what he meant. He simply divided the $125 million loan with the number of low-cost apartments planned in the construction project.
We're spending $2.5 million per low and moderate cost housing apartment. Believe me, I would love to move into a $2.5 million apartment because you can get one on the top of Wilshire Boulevard as a penthouse right now with a fantastic view. Give me the $2.5 million, move into that wonderful penthouse. Who needs a Jerry Epstein apartment on the bottom floor?
His concern is that the government is using our funds to subsidize the wealthy, and this is negligent use of public funds.
HUD has a certain amount of money that is allocated to it. And once this money is allocated, they can't double allocate it. You know, this money's gone. You know, it's been budgeted and it's gone. That's the end of it. If they double allocated it, that's a whole nother set of crimes. I mean, that would really be worse. But I'm assuming that the $125 million is taken off of the budget, it is set aside, and that's it. They cannot go out and do, you know, what the banks did, where the banks would go in and they say that we have $40 real in our account, and with that $40, we're going to go out and we're going to make loans for $400. And then when those $400 of loans fail, the bank says, oops, you know, we don't have the money to have covered those bad loans.
So the Department of Housing and Urban Development has a finite amount of money to use in implementing its mission.
HUD's working at 100%. Has $125 million as a loan guarantee. That $125 million goes off its books. If HUD is working at $125 million available for a loan guarantee and they're actually lending out $1.25 billion, or they're guaranteeing $1.25 billion against that $125 million, then we are in far worse trouble than anyone could ever imagine. Because that's what happened to the banks. The banks went in and they only were required to have what we call a certain amount of a reserve. And whether the reserve was 5%, 10%, 20%, that was the amount of cash that they were required to have on hand, and they were able to lend out, you know, up to 10 times that amount or whatever the amount was. They went and they lent that money out, or they invested it in derivatives or other things that nobody could quite understand because it was all made up in somebody's head, and they lost it. And the bank went down.
He has read the HUD loan guarantee application.
Beyond this corporation, we can't get anybody. Corporation's it. That's as far as it's going to go. This whole thing goes down, that's the end of it. Just looking at that, you know you've got a problem.
So the limited liability protections are there to shield the principals from any legal responsibility should this project go south. The Epsteins have done everything they can to make sure they don't lose any money in this deal. but they've set their hooks into the taxpayers by getting HUD to approve the guarantee. And as Dr. Fine points out, there is an entire sordid history behind that guarantee.
In these papers, they talk about Jerry Epstein and his other things. Realistically, they can't get to him, but when you start looking beyond that and you start looking at Epstein and you start looking at the chain of title of the property, suddenly you're only looking at the shores, but then you have to look behind the shores and you have to look at Delray Shores Joint Venture and Delray Shores Joint Venture North. These were the people that owned the land lease from the county immediately before the shores and immediately before the insurance company got involved. You have to look, now what happened there? And then you have all this litigation with respect to the EIR, which is what's happening as to how this building is supposed to get built. And you're looking at whether the permits are actually valid. And now you're looking at the money that was paid to Kanabi and Tanovich, Yaroslavsky, Molina. Prior to that, Burke. You're looking at the money that was paid to Yaffe. None of this is disclosed, but it's all out there. And you're looking at the Epstein's bankruptcy on his West Side condominiums or whatever that other project is. When you take all of that into consideration, there's no way that you can guarantee $125 million. And that's why I say when I started out, the U.S. attorney is lying when he says they don't conduct investigations, because you can't indict a person unless you've conducted an investigation. In order to get an indictment, you have to have conducted an investigation. That's number one.
So investigating this possible crime is the #1 activity of the U.S. Attorney's Office, even though their letter says it's not. Who is responsible for this startling inconsistency? When we come back, we'll ask Dr. Fine to discern where the responsibility lies for this contradiction. We'll be right back.
For the news behind the news, wherever and whenever you want it, go to fulldisclosure.net and get programs on topics affecting you, weekly updates and alerts on hot topics, video streaming of Full Disclosure episodes. It's award-winning, hard-hitting, corruption-fighting news coverage. And it's only available at fulldisclosure.net. Fulldisclosure.net, the news behind the news.
Welcome back to Full Disclosure and our interview with Dr. Richard I. Fine. We asked Dr. Fine to explain how this letter could be written when it is in such obvious conflict with the purposes and policies of the U.S. Attorney's Office. What were they thinking when they wrote it?
At the top it says U.S. Department of Justice, United States Attorney, Central District of California. So it doesn't matter what they were thinking. The letter is coming from the United States Department of Justice, U.S. Attorney's Office. Andre Barot is the U.S. Attorney. Could care less what they were thinking. This is an official communication from the U.S. Attorney for the Central District of California, and he is the representative of the Attorney General Holder, the United States Attorney General in Washington, D.C.
The fact that the letter was written as an official government document makes the Justice Department responsible for what is written in the letter. They can't excuse what it says by blaming some mistaken or misinformed subordinate.
The document, as we say, speaks for itself. I don't have to get involved as to whether they hired an idiot or whether they hired a genius. As all I have to deal with is a document which on its face is an out-and-out lie.
So where does the responsibility for this lie?
We have the United States Attorney General's Office that says they do not conduct investigations, which is a total lie. So what we have here is we have HUD doing a cover-up, the Attorney General lying to us as to what their job responsibilities are, which is basically a second cover-up. So we have cover-up upon cover-up. effectively, we have a breakdown of the entire enforcement positions of the United States government.
Perhaps Dr. Fine is overstating the situation, but he does an excellent job of supporting his conclusion.
You have a person lying on their application to get the $125 million loan, and we've shown that. You have HUD giving out the loan based upon the false application. You have HUD trying to cover up the actions by ordering the documents destroyed and wanting them all back. Then you have the U.S. Attorney's Office, who is supposed to enforce the law, coming in and telling you that they don't conduct investigations. Now, let's take this U.S. Attorney's letter. If this were true, that means that every dope dealer was not investigated. That's going to mean that every financial crime or every other crime was not investigated.
We asked Dr. Fine to explain where he thought this is going. As full disclosure, we will continue to follow this mind-boggling series of events. What does he think will be the ultimate end, we ask him.
I'm hoping that this is going to turn out that because we have shed the light on what is happening and because we have shown the U.S. Attorney's Office and the Department of Justice, which doesn't investigate things, that exactly what to do and literally exactly whom to call in their grand jury and exactly what to put in their indictment and exactly what to do for their conviction, they will follow our lead, conduct the investigation that they don't do, impanel the grand jury that they are required to do under law, pull the witnesses and the documents into the grand jury, get the indictment, proceed with the trial, and get the convictions. That is what I would like to see happen.
But this is the real world where government officials spend their careers dodging responsibilities, covering up their mistakes, and persecuting the weak and the helpless to make it look like they're doing their job.
And if that doesn't happen, then I think we should have a special prosecutor called in. We can get a 3-judge panel to impanel a special prosecutor, have the special prosecutor come in and do the exact same thing. Well, I can tell you something. This whole thing can be put together in literally a couple of days. We aren't talking about a large expenditure of resources here. You can take a couple of good people and a couple of days, and this entire thing could be put together, the indictment can be gotten, and the prosecution can go forward, and this case could be tried. Actual trial time could be tried in probably no more than 3 to 4 days at the most.
We asked him if he thought the fact that full disclosure was bringing to light this ongoing corruption, that the U.S. Attorney might reconsider his flawed statement and reassess taking action to investigate and prosecute the fraud within HUD.
No, I think the U.S. Attorney is compromised at this point in time. I think that Andre Barot, he himself is compromised, and his office is compromised by this letter. They're out of it. I think that there's also a question as to whether Holder, the Attorney General, and the Department of Justice can be considered to have the necessary integrity to go forward. Because this type of a letter can be indicative of a mentality that is existing in the Department of Justice, which would compromise the integrity of the department. If this letter is any indication of letters that are customarily going out from the Department of Justice throughout the United States, then the entire integrity of the Department of Justice is compromised. If this letter is something that is just coming out of the local office here, then it's only the local office that is compromised. But there is a very, very serious question as to the integrity of the Department of Justice at this particular point in time. And that's why if there is going to be any federal prosecution on this, it would have to be coming from a special prosecutor.
How difficult would it be to appoint a special prosecutor, we ask him.
You have a 3-judge panel. You can go to them. You can get a special prosecutor, and you can have all of this taken care of, and you end up cleaning up Los Angeles County and the judiciary all at the same time.
We want to know what you, the viewers, think. Do you think that we need a special prosecutor to begin a major investigation of Los Angeles County, the Superior Court, and the U.S. Attorney's Office and the Department of Housing and Urban Development? Please call our Full Disclosure Town Hall number and let us know what you think at 1-800-867-7777. That's 1-800-867-7777, and leave your name and number. We will get back to you. Or you can log on to our website at fulldisclosure.net and leave your opinion there. And if you leave your email address, we'll be happy to respond. I'm Leslie Dutton. Please join us next time for another edition of Full Disclosure. Thank you.
To respond to this question or comment on this program, please call 800-867-7777 or visit fulldisclosure.net. Transcripts or DVD copies of this program are also available on our website. Full Disclosure, the news behind the news.